I think it's some basic house rules, because yesterday, I mean, we are all in agreement that it was our first day. So I did take time to give everyone an opportunity to get a feel of, how things work with court practice. And I think I allowed a lot of questions, which are still going to be allowed, but I would only plead, because I also noticed that we found ourselves in situations where I would say something, I don't know whether people were not really paying attention, then you would debate it amongst yourself until one of you actually repeats what I had already said. So for the sake of time, I think after we clarified that, let me present the item that is on the slides, and then if there's any questions, we try and keep ourselves brief and try to address the questions so that we can move swiftly along. So I'm not going to say let us reserve all the questions to the end of the evening, because you might forget, and it might cause us having to go back to the slides, once we have finished for the evening. So I will only request that when we do ask or give some comments or inputs, we are mindful of time. So I see that now it's 5:44. I don't want to be like a Hitler. I allowed us to proceed yesterday without any breaks, because things were just flowing naturally. So I wouldn't want a situation where I'm seen to be a slave driver. So I think I will request that if someone can keep a time for us and alert us when it's at least 7:35, so that at least we can stretch our legs, take some bathroom breaks, and then we can have at least 10 minutes. 7:35, please. I don't know if we have team leaders here, but I don't know if we have the class leader or someone who can help us with that. But even if you are not the team leader or the class leader, please alert us when we reach 7:35, so that we can take that 10 minutes break and stretch our leg, take some bathroom breaks, and then we continue like that. So that is that with regards to the house rules. Ladies and gentlemen, we covered basically a lot on the introduction of what the sources are of criminal court practice. We touched also on the participants in a trial, and we went as far as reaching this particular slide that is on the transcribed records. And I do mention this because it is one of the big challenges that you would encounter in practice. So the only thing that I would like to say there before I move to the next part of our lecture is to say that transcribed records, I know the standard in it's, if you are requesting for such records to be compiled, it takes about 5 weeks, but depending on how much of the record has to be transcribed, it may actually work out to be less time. So if you foresee that really that will be too long for you to move along with your case, then you are more than allowed to request to be given a copy of the record. It will be made into a disc, and then you can make time to listen to it. That you can do in a day or two, and then at least you can move along with your matter. So that is just to advise on that process of obtaining the transcribed records of the proceedings. Today we are entering a new phase of the trial proceedings. Actually, it's a pre-trial stage. And here we are going to focus largely to a very large extent on basically what happens before the matter proceeds to trial. So we are going as far as you getting to know about the case. So it would depend. Sometimes you may receive a call from family members of the accused person who inform you that please take over the matter and assist the accused who's been held at a particular police station. And then that would be when you would go to that police station and meet them for the first time. And it may be that sometimes if they can also approach your office, I mean, the accused themselves can come. But in criminal matters, especially at the earlier stage, you find that you are most likely to the first encounter that you will have with your client is when they are already held up in custody. So it may be at the police holding cells or at the court cells. So it is important that immediately when you meet or you are given this case, you can obviously try and get as much information about the case itself from whoever has approached you. But it is most crucial that you immediately meet your client who is the accused so that you can be able to hear from them anything else that might not be known by maybe the family members. So once you have now introduced yourself to the client, you will then first of all have to know who's the investigating officer, because that will be the police officer who will have more knowledge about the case. Now, when you take on a matter after you have done your brief consultation with the client, you need to determine whether you are equipped to handle that matter. If you don't have all the knowledge, will you have enough time to do proper research and preparation for the matter? So it is not just to be excited when you see money flashing in front of you. You need to be able to make sure that you will be able to execute the mandate that you've been given. As I already stated yesterday, that once you have placed yourself on the record, it is assumed that you have the necessary knowledge, the technical abilities to execute this mandate. So you cannot come and later plead inexperience or say that it was my first time and things like that. Once you are on record, it is deemed that you know more than, automatically it's assumed that you know more than your client. So I say on the slides that you should avoid taking on a matter that you would find that you will be ill-equipped to handle, or finding yourself taking on too much, and you will now find a situation where you would have to pass the work to your juniors. Once you are obviously running your own office, you will be passing the cases down to the junior staff or asking paralegals maybe in your office to actually take on the matter. Remember, the client is paying you and they are expecting you to be the ones who will see to the finish of the matter. So if you are going to be reliant, obviously, on the junior staff, proper supervision should be done. So this is a common thing that you find, that you see that a lot of junior legal practitioners will just, rock up in the courtrooms and they don't even have a clue. They've just been given a file and they have a gown and they say, go to court. They don't even know what the matter is there for on that day. They don't even know, what they do. So, we try to avoid those kind of conducts that will make you to look unprofessional and seem as if, you don't know what you're doing. Also, the rules of ethics do not allow what is known as double booking. This behavior is unethical, where you would actually be booking yourself, for example, to be appearing in different matters on a particular day. You know, in practice, you find that obviously because people are trying to make money, they will try and take, you know, as much work to keep afloat. But if you are taking work, you need to be able to ensure that when your matter is called in court, you will be present, or you will have someone who will be there for you. You do not want to be known as that lawyer who always sends messages that I'm running late or I'm not able to come through, because you will find presiding officers who will not take kindly to that. You will be reported for actually double booking yourself, where you took a chance and, you know, you thought, I can quickly run to the first court and maybe get the matter postponed and then quickly run to another court. And you find that they may have started with your your second matter on the roll. By the time you get there, it's been disposed of. So that is a behavior which is unethical, and it is completely goes against the rules of ethics, and shows that you cannot be relied upon as an attorney, or rather as a legal practitioner. Now, when you take on a matter, it is also highly important that you ensure that the cost implications, we are talking about fees, that they will be fully explained to the client, to ensure that they are fully aware of how much it will be costing them to take on the matter. One of the most popular things that we see is attorneys who would take an instruction from the bail stage, and they will proceed to do the bail. And then once they have actually finished with the bail, now the matter is postponed to go on to trial. Now the matter comes back to the court, and the accused is standing on the dock by himself. It is quite irritating to the court when they ask the accused, where is your lawyer? So please ensure that you have explained to your client that, look, the money that you are paying me, it's only going to cover for the bail. And once we have done the bail application, I would need you to deposit further funds for me to continue on the record. Explain to them that if the matter is going to be prolonged, because sometimes cases do take longer than you would normally anticipate, explain whether you would be charging per appearance or per postponement. Do you have a standard fee? So let them be fully in the picture of how you are charged, because, you know, as we said, our clients are lay people, and they would assume that if they paid you that initial amount that they paid you, they thought you would be there for them until the end of the matter. So make it clear to them that this is what I'm going to do for you. And once it is done, make them fully aware that now the money you have paid me has covered, as per our agreement, what I was supposed to do. And at this stage, if you would want me to continue, I'm expecting you to deposit further funds. And ensure also, for the sake of your reputation, that you inform the court that your instructions were only for you to cover the bail. Now, once that the bail application has been dealt with, then you would inform the court that the court has to excuse you from the record, so that when the matter comes back, they will not expect to see you. They will not. So they would know that your money was only. Yes, sorry, I'm back. They would know that your money was only to cover up to that bail stage, and you've been excused from the record. Now, when the accused appears on the next occasion, they will be asked by the court, what do you now intend to do? Because on the last occasion, your lawyer has indicated that they were only instructed to deal with the bail application. The matter is going further. Do you still want to get the services of the same attorney, or do you now want to proceed on your own, or do you want to take legal aid? That is how it works. Okay. Yes, there was someone who wanted to say something.
Yes, it's me. Okay, thank you, Elsie. I wanted to ask, in terms of fees in criminal court practice, is the standard tariff like they do in civil matters, or you charge according to your work and experience?
That all goes together. There's tariffs which are set to be a guideline. It's not a hard and fast, but it's a guideline to the practitioners to show that in this court, these are what would be the tariffs that you would charge, because you cannot expect to be paid for a postponement. I'm giving an example. 2,000 rands in the district court. And if the matter is in the high court, that you will be having a senior counsel or a senior legal practitioner also being paid 2,000. So there is the tariffs which are there to give a guideline to the lawyers to show how they should charge. But they are allowed to, like you said, based on their experience, they cannot all charge the same, and they can work around the fee structures.
Hi, Elsie.
Yes.
Can I just interject?
Yes.
I'm sure that we are going to cover that under legal costs.
Yes.
Audio that will cover that particular issue.
Yes. So, but I just had to say that obviously there's tariffs, like then someone will follow what is in the tariffs. Any other questions, ladies? I'm moving to the next slide.
Yes, ma'am.
Yes, I have a.
Okay.
Hello.
Yes.
Yes, I have a question.
Yes, ma'am. Can I ask regarding bullet point number 2 on your slide?
Yes.
We are urged there that as a legal practitioner, we should not take matter and pass it to junior officials. Are you still with me?
Yes.
Yeah, then my question is, what's the reason for candidate attorneys to be given a right of appearance if we cannot pass them matters?
No, they have to work under supervision. I've already said that. So their principals will be there to supervise them.
Even if he or she has a right of admission, I mean, a right of appearance.
A candidate legal practitioners from the start to the finish of the articles always works under supervision, because the principal has to sign off everything that they are doing. They are not yet fully qualified.
When you are admitted, you are now an attorney.
Yes, when you are admitted, now so you don't need to be supervised by a principal.
Principal.
Yes.
So you can still do the work. You can join him maybe when he's when they, what is it? When they're busy consulting with the client.
You can, yes. That's what happens in most firms. The senior would sit in with the candidate.
For the candidate to go and represent the client, because you already know what's happening.
Yes. Okay. I think that is clear. All right. Okay. I'm moving along.
I just ask the question.
Sorry?
Yeah, I just want to check. Yes, I just want to check that you indicated that if you take a matter, then you get paid. But in an event that it happens that the client doesn't pay me, do I have to make an application to court, or must I inform the court when the court proceedings begin or have begun? Or should I just maybe between me and the client say, no, I'm no longer going to represent you because you did not pay me?
That is unprofessional behavior. When you took on the matter, you came and you placed yourself on record.
Yes.
That is basically you coming to appear in person in court, or you can send a notice of appointment to the prosecution to let them know that you are you are mandated to be the attorney of record. Now, if you have such a situation where the client doesn't pay you, it's on record. The charge sheet would continue reflecting your name until you come and you inform them formally that you are not proceeding as the attorney of record. So you should be professional enough to also, you know, you don't have to come in person. You can just send that notice of withdrawal to the prosecutor's office with all the details of the case, so that they will then, or to the clerk of the court, so that when they draw out the charge sheet, they can ensure that it reaches the attention of the court that you will no longer be proceeding with the matter. Don't just disappear. I hope that is clear. Okay.
Thanks.
All right. Okay, so the first part of this pre-trial deals with mainly the rights of the accused person. And I have mentioned, as it is on the slide also, that every accused person is presumed to be innocent until proven guilty. We discussed also the provisions briefly, because it's a long section of this section 35 of the Constitution. So I will not dwell too much on the discussion on this, but except to say that this is where the rights are founded from. The rights that I will be discussing, and these are the rights of the accused from the moment they are arrested, detained, and when they are undergoing trial up until the end of the matter, if it's a finding of guilt and they are sentenced. When the matter is now wrapped up and the case is finished, these rights are going to be finding application, particularly to the accused person. So I'm not going to discuss all the rights. I'm just running through some of the most prevalent rights that are there, but please let us not waste too much time, remember, on just one particular issue, because there's a lot of things that we need to cover. So I will touch on a particular right, we discuss it, and then if you want to know all the rights, then it will be left, as Ntate Malema has said, for self-study, for you to appraise yourself with all the rights which are applicable to an accused person. Okay. So the first right that an accused has, it's a right to remain silent. This right kicks in from the moment that the accused is arrested. So this means they must be informed by the arresting officer that you have a right to remain silent. And this right must be repeated through the different stages of the case to the accused. As they come to court, they will be informed also by the presiding officer when they have to deal with the trial itself, or if they want to maybe make any statements. The court can sometimes remind the accused that they have a right to remain silent. So where there is a statement that the accused is making without being informed of this right, this renders any such information inadmissible in court. And at the start of the trial, the accused can also elect to exercise this right and remain silent by not making any opening statements. Now, when the state is closing its case after it has led its evidence of their witnesses and whatever evidential material that they presented to the court, the lawyer, you can discuss with your client also about this right for them to exercise the option of remaining silent. Now, if the client elects to exercise this right to remain silent at the close of the defense case without leading any evidence, that means the accused, as the state has called all the state witnesses who testified, and the state has now said, we have presented all our evidence, all our witnesses, at this stage, the state case is closed. now the defense will be given an opportunity to also now present their case. If the accused elects not to say anything and also not to lead evidence, then the attorney would inform the court that the accused is electing not to lead any evidence, not to testify, and he remains silent. So this one is quite tricky, ladies and gentlemen, because if at that stage the accused is choosing to exercise that right to remain silent, when it's now his turn to tell the court from his own side of what they're saying is their defense and call witnesses or present whatever evidence that they would have used, and they elect not to call any witnesses or to lead any evidence, the court can sometimes draw what is called a negative inference from that, because sometimes it may look like the accused is trying to hide something. Because remember, the court is now sitting with the information that has been presented by the state and their witnesses. And it means that the court will then have to make a judgment based on only what is before it. So it doesn't mean that the accused cannot exercise this right at that stage. But if you are opting to take that route of remaining silent after the state has, called witnesses who have said things before the court, make sure that there was nothing that was damaging, to the case of the defense, or things that have in any way implicated the accused, and that would also call for the accused to have to come and answer to the allegations made by the state witnesses. Only if you are certain that there is really nothing linking the accused to the commission of the crime, and you are of the view that with the evidence that has been presented before the court by the state, there is no court that can make a finding of guilty. You are that confident. Now it's your judgment call as a defense lawyer. You will then go to your client based on your knowledge of the law, and then you will advise your client that, my client, from what these witnesses have said here in court and whatever evidence that has been presented, I am of the view that you may elect to exercise your right to remain silent, and we're not saying anything. Because why this is important is the minute the accused takes the stand to testify, they are being opened up, obviously, after you have led them to tell the court their story, to now being exposed to what is known as cross-examination by the prosecution. And that is where, they are really exposed, and at that stage, things can either go left or right, So you wouldn't want a situation where, if you don't have confidence in the manner in which your client will be able to present their own case, that they will be able to stand firm against that cross-examination, and the quality of the evidence that is already before court on the side of the state, you are confident that there is no damage done, then you advise your client not to say anything. Now,
Ma'am, can I ask a question?
Yes.
Is this the right time when your client you look at the case and you see that there's nothing that they can charge them on, or maybe there's a possibility, a slight possibility? Is this a time where you run to Section 174?
No.
Or it's not necessary?
Yes, you can. That's where, I remember, you only apply for 174, which I'm still coming to briefly, to say that once the state has now presented their case, you would only bring that application for 174. But sometimes I'll discuss also on 174 what will make the court to not grant you that that application, and it calls for you now to come and deal with a defense case. So now, if you are certain that really, like I said, there's nothing here, and maybe you have actually even applied for that 174 and the court has not granted it, because it can happen that you ask and the court is like, no, there is a prima facie case, I'm not granting your application. Defense case, proceed. Then you are still confident that there is still nothing that the accused must answer here. Then you will now make that a judgment call and advise them accordingly.
Ms. Elsie.
Yes.
Yes, may I ask, please? Yeah. What happens in a case the accused decides to oppose your advice and wish to go against it, you know, and wants to testify against your advice? Do you allow them? Is there a way perhaps you can, I don't know, stop them from doing that?
You warn them of the danger. Why do you think they will not be able to be good witnesses on the stand? You know, based on how you consulted with them, you would show them the things that are of concern to you regarding their case. And you will tell them that, look, even me, I'm having concerns about this, and I've addressed these issues with you. You have not been able to satisfactorily answer these questions. Now you will not be cross-examined by me, your lawyer. It will now be the state, the prosecutor, who will be coming guns blazing at you. So my advice to you is don't, testify. But if they elect that, no, I want to take the stand, because you do get those, then remember what I said. Your discussions with your client should always be reduced down to writing. That part of advice, you will note it and make a note of it, and you will then say, upon my advice that it is not, wise for you to proceed with testifying, the accused still elects to take the stand and testify. And the risks have been explained to them, and they are willing to go and face the fire. So then please sign for me. You are fully advised, and I will do my best, obviously, to prepare you again, for what is likely to come. But obviously you can't predict every weapon that the prosecutor will throw at them, because they also have their own strategy. So you will do your best to prepare your witness, but the rest will then have to be dependent on how they will fare when they are being put to the stand. And then at least you are covered, that you have it on your notes that I advised you. So you don't have to force them and say, no, I'm not, advising you. If they are strongly feeling that, no, I want to say something for myself, then you advise them. And then remember, you take instructions from the client, but your advice must always show its head, that this person is not just going on blindly, because you are now the legal practitioner who, if there's any problem, you may be called at a later stage. Then you would be asked, but say, why didn't you advise your client, seeing that this was the danger that they were exposing themselves? Then you'll be like, no, here is my proof. This client was fully advised, and they elected, obviously, to do as they pleased. And yeah, that is how it works. So, but if you find that it's something where now you are fighting, just be careful. You don't have to fight with your client. If you are fighting, then you have a problem. Obviously, now you are trading on conflict, so just be careful. But you can't force them. Bottom line, you can't force them. Okay.
Can I ask something?
Yes.
I wanted to check at which point of the trial can the accused make an opening statement?
We'll get there when we are dealing with the trial. This is the pre-trial stage, ne?
Okay.
Okay, thank you. Okay, the next right.
Can I make a follow-up on the question that was asked before this one, Elsie? I just want to check if, do I have any option to withdraw? And when I withdraw, do I have to state to the court or to the prosecutor that these are my reasons for me to withdraw? Because I think if there's a conflict or my clients, we are not gelling well together. I'm sure there is that option, but I just want to confirm if I may withdraw.
When you see that now it's a conflict, like I said, you are no longer just having a difference of how you view the case. now it is now a conflict. Obviously, you now have to withdraw from that case, because you always have to act in the best interest of the client. And if you are conflicted, you cannot do that. Now, when you withdraw, you cannot say to the court, I'm now withdrawing because my client does not want to listen to me and is deciding to be stubborn and go ahead and do as they please. You will have to be careful with the words that you will say. For instance, you will tell the court that at this stage, I've consulted with my client, but I have come across a conflict when we were doing our consultation. So without divulging the exact issue, I'm finding myself ethically challenged in this matter, Your Worship. The court knows when you are ethically challenged, you cannot stay on the record. Now I'm going to request the court to excuse me so that someone else can take over, who will be able to do what is best for the client. It's not an issue. The court will not even ask you, why? What is the issue? No. Any court that asks you, you just have to block them and say, no. At this stage, that is all I can inform the court, that we've come across a conflict. I'm not going to be in a position to proceed. I'm asking to be excused from the record. And they will excuse you.
Thanks.
Thank you.
Ma'am, can I ask?
Yes.
I just want to find out, and then when we withdraw, do you have to refund the client, or what should happen there?
No, you don't have, unless if they've paid you in advance to the finish of the matter, depending on, you'll do your balancing of your books, and then you'll bill them accordingly to say, this is what I've done, and up until here, this is the fee, and here's your balance that is due to you. Then you refund them what is still due to them.
All right.
Yes.
Question?
Yes.
Normally in other proceedings, it's allowed just to send a notice of withdrawal. Is it mostly allowed in, is it also allowed in criminal matters that you can just send a notice to the court that you are withdrawing your mandate?
Yes. You don't have to state
reasons.
You don't
have to appear?
You don't have to appear. You can just send that to the prosecutor. If you know who they are, you give them a call and say, please give me your email address. Let me email you this. So that, because they are the ones who are going to be calling the case, they would be able to inform the court that, Your Worship, we've received the notice of withdrawal, and the accused will then be advised by the court to say, you look, the lawyer that was on record has withdrawn. Please tell the court now, what do you want to do? But obviously, for professional reasons, try to be humanistic in your approach. Engage with them and tell them that, look, I'm not going to be able to come. As you know, we agreed for you to pay me like this, or whatever is making you not to continue. Talk to your client. Don't just disappear on them like, you may never know that tomorrow they may wake up being the latest lotto millionaire, and, and you would love to have them as a future client. So, so always keep things professional and cordial. Okay.
Sorry, can I find out something here? I didn't hear that, and I think another person there asked that question. At what stage can we withdraw? At the pre-trial stage or at the trial stage? It doesn't matter.
At any stage, even if you are in the middle of the trial, you are still leading evidence. At any stage of the proceedings, you can do that.
So can we agree with with regard to the issue of professionalism, that what we saw, or what we witnessed last year on the case of Senzo Meiwa, the advocate withdrawing and deroping in front of the court, that it was unprofessional?
I'm not going to make that judgment call, guys. Please don't put me in that corner.
That's fine.
I think there is a course that you are going to do on professional ethics. It's one of the courses, but I don't want to be quoted that LCCB said Mr. Tefo acted whatever. But the rules of ethics are there to guide us as legal professionals on how. That is why when I say to you, even if you are not paid, don't just disappear on them. You are a professional person. That is why I say inform them that, look, we agreed like this and you're not able to pay me, so I'm going to withdraw. I feel like I'm spending too much time on this issue of remaining silent. Now we're discussing fees and whatever.
Sorry, last question.
Can we deal about the rights? If it's not about this right of remaining silent, please, we need to cover other things.
All right.
Yes. Is that about this right to remain silent?
No.
Okay.
I have a question.
Yes.
Yes, ma'am. Regarding the right to remain silent. Okay. My client advised me that he or she wants to remain silent when I'm supposed to tender evidence as a defense. Now, at the later stage, after I have presented maybe few of the witnesses from the defense, now my client decides to speak on his behalf. So at what stage can the client waive this right to remain silent again?
Okay. Now, if initially the accused had said, I don't want to talk, but you can call my defense witness and you lead them, you present whatever evidence that you have for the defense, and later he changes, he's entitled to do so. Obviously, you would have to check whether, it's not going to spoil the good job that you have done. And if you are happy, then you inform the court that the accused can now take the stand. So basically, the case is yours. There is no hard and fast rule to say is the accused who must be number one to testify on the case of the defense and followed by their witnesses. So you can start with the witnesses and finish with, it's your prerogative. You decide how you want to present your evidence. So at any stage, you don't even have to say that I'm not, you can even say initially, I'm not going to call the accused, but if you see how the case is flowing, that it will be necessary and the accused says, no, now I want to testify, and you both agree, then before you close the defense case, you now have to say, now the accused has changed, his mind, and he's taking a decision to actually now take the stand and testify. That is not going to work against them.
Thank you, ma'am.
You are welcome.
Ma'am, there's something that I do not understand clear.
Sorry, ma'am?
I'm sorry to ask this question. I think you explain it. So what happened if the accused is guilty, but he decided to exercise his right to remain silent? He will get a sentence for this, or he would get a punishment. If he is guilty, but he decided to exercise his right to remain silent.
But a guilty person cannot go to trial, ma'am. If you say your client is guilty, then it means that you have entered a plea of guilty. It's not a trial anymore.
Oh, okay.
Please don't confuse those two things, ne?
Oh, okay, thank you.
Okay. Okay, the next right is what is called a right against self-incrimination. For the last speaker now, please pay attention. Self-incrimination is where the accused is blaming themselves or accepting having committed the offense somehow by some statements that they are making before the court. So if the accused is incriminating themselves, then they will be found guilty based on their own words. So anything said by this client can and will be used against them in court. So if this client was to testify, you need to make them aware that they should not incriminate themselves. That is where you are pleading not guilty. Okay, now, the lawyer should, during consultation, assess, as I said, preparation is key. Whether the strengths, the strengths and the weaknesses that they have when they are likely to testify, where you see that they are likely to expose themselves to danger, you have to help them on their weaknesses and help them to be prepared to testify, and always warn them that the duty to prove the guilt of the accused rests on the state. The accused is not there to assist. Sorry, Kamukelo, please mute. The accused is not there to help the state to prove his guilt. The accused merely has to give the court an explanation which is possibly true. Possibly true. So that does not even mean that the accused must tell the truth. They have to just give an explanation which to the court, when it listens to it, it can conclude that it's likely that the accused is possibly telling the truth. Okay. Now, when you are preparing for consultation, when you are consulting with the client, always important to warn your client when you see that they are exaggerating or they are underestimating the state case. Warn them where you see that they are, undermining the evidence that they think the state will present against them. Because if they are found to have been exaggerating on their version of events, obviously the court will not be impressed by that. So you always have to help them to find a balance, not to overestimate, not to underestimate, and to keep things on a fair balance, like I said. But you are not telling them what to do, or means what to say, rather. You're just helping them on how to present the events to the court. Okay. Okay. The right to docket access, I discussed it briefly yesterday, that this right is only available, it's not available to the accused at the bail stage unless permission is given by the prosecutor. Now, this right to the docket is immediately available to the accused after the state has declared that the investigations are complete. And please make a note that where you are given a docket in court, because there are prosecutors who are not so strict with the handling of the actual docket, that there is a part called Part C on the docket, which contains a diary of communications between the police and the prosecutor. You are legally not allowed to open that diary and read what the police and the prosecutors are discussing. That is communication that's privileged to them. So please ensure that if they are, flexible enough to allow you to actually handle the actual docket, because maybe based on your level of friendliness with them, that you don't cross that boundary. Please check only the witness statements and what is applying to what you have to answer concerning your client's case. Okay, I think that one is clear.
Sibi, may I ask?
Yes.
Okay, I understand that this information is from the defense lawyer, but I'm asking in a situation where a complainant is requesting to have access to the docket, and after the case has been closed, but realize that some of the evidence was not submitted. So meaning that the case was contaminated throughout the obtaining of evidence. What is the situation now in order to remedy? I understand that maybe there is a remedy to write to the national DPP. There is a right maybe to make representation to whoever is above the prosecutor who made the decision. But what then? Because this happens a lot. I have witnessed it where I found that the docket had missing information. Some of the evidence was thrown, did not even reach the prosecutor's office. But we are saying that some information is privileged only to the state. So what is the situation now? How to deal with this matter? I'm asking from maybe representing the complainant. Actually, I'm asking where the complainant is taking the initiatives, because I believe as a lawyer, perhaps I will be privy to have those documents when I'm requesting. But it happens that information is submitted by the state during their investigation and the information is missing. Some is even tampered with.
Okay,
Some have not been submitted at all to the prosecutor.
Yeah, Connie, I hear you. Please, I think you already clear on the fact that one, the complainants are state witnesses and their lawyer is the prosecutor. And if there's any issues concerning the handling of the case, from the police side, there is the station commanders, there's ranks within the police in terms of reporting corrupt activities or interference with the handling of the cases within the police force. So the same applies also with the prosecutors. So there is nothing for us to do as defense lawyers to interfere in how the state is running their case. That is a matter to be handled by the state and the police. So it should be reported with the authorities on that side. Okay.
Question?
So I just want to check it. Yeah. I want to check something. You were saying that on the docket, there are sections. I know them to be 5, but you see that you are warning us against. I'm just checking that why would they give me a docket which contains a privileged information in a form of investigation diary?
Because they do.
I understand that I must not look at it. Do they? Yes.
Because they do in practice. In practice, people are relaxed, even though that is why I said depending on your level of friendliness with them. Others, they would just, instead of going to make you copies that apply to you, they would, like for instance, you see what I say on the bail stage, you are not entitled to have access to the docket. But based on how you relate with the prosecutors, there are some who can give you permission to take a seat and right there read through, not actually give you copies, but you can read through. It happens. What I'm talking is something that happens every day. Go to any court, it happens. But the rules are that you are not supposed to. I'm telling you the rules as they stand, but what happens in practice, I cannot tell you to do the wrong thing, but I have to tell you that you don't want to be accused of having, head side of their diary and seen who are their potential witnesses, and you went and you contacted those witnesses because their information is discussed there, and then you contacted the witnesses, you sent people after them, you threatened them not to cooperate with the police. You understand why I'm saying this? That is the risk. If you are, it's a very serious issue if you are said to be interfering with the running of police and the state investigations. That is why. Okay. Clear?
Thanks.
All right.
Question?
Yes.
Yeah, my question would be that because we are not allowed to, as the friends, we are not allowed to have the docket at the bail application stage. Is there like any other circumstances that maybe you would have an exception to get a docket, maybe because of a certain merits of the case, to say that you are required to have a docket and you can therefore make an application for that?
You mean at the bail stage?
Yes.
No, there's no exception except the the indulgence that the prosecutor can give you to just read through the docket. Otherwise, you would only have to rely on what they will tell you or give you a statement. That's a statement that is prepared by the investigating officer who has interviewed the witnesses, who knows the type of evidence that they intend to use against the accused. And that can be given to you because it's the statement of the investigating officer which can be used during the bail application, and you can call the investigating officer at the bail. But we are coming there, guys. So, but at this stage, you can't force them in any way. There is no right. That's the bottom line.
Mamelsi?
Yes.
Yeah, if I may.
I think that's something.
I want to ask, so when it comes to the docket, in what format is the docket? Is it the manual docket, or do they have electronic dockets?
It's manual dockets, and I know that they are busy with a project of digitalizing their systems to make an integration of the systems from SAPS, NPA, Social Development, Department of Justice, Home Affairs. So the idea is that initially it will be that brown booklet, I don't know, for lack of a better word, which is containing all those things inside. And then once they are moving to digitalizing it, then they will scan the documents that are inside those dockets and upload them on a digital format. Then parts that are relevant to the defense would then be accessible for you, depending on the stage of the proceedings, that you can be given access to that. That is the future. We are not there yet. We are still working with manual things right now.
Ma'am Elsie?
Yes.
Does it happen that upon application to the court, hello?
We are listening.
Yes. Does it happen that the court will refuse the access to the docket after the refusal of the prosecutor? And no, not during bail. Say it's after bail, after the state has mentioned that the investigation has been completed. Then the prosecutor and the investigation officers refuse access to the docket. Then upon application to the court, does it happen that the court will also refuse access to it?
No. The matter can even be postponed. When you say before we get to the trial, I'm not going to confirm the date for trial before I am given the contents of the docket. So I don't know which court would allow at that stage, because the access that you are given is so that you can go and prepare for the trial, so that you don't come on the trial date and you say that you are not ready. Okay.
Question, ma'am.
I just want to check, as you were saying that.
Actually, I wanted to ask, how do you access the dockets? Does the prosecutor give it to you and you make copies, or do they make copies for you?
There's normally forms that you can complete at the offices of the prosecutors there. They have standard forms where you put in the details of the case, the names, the case numbers, and what you want. Then you submit that form to them, and then when the copies are ready, you will go and collect them. And they normally have a central place where the copies of these dockets are kept. So you can just go and collect your copies of the docket there.
I just want to check, well, as you were saying that they are working on digitalizing the issue
That's
of
the
dockets.
future. It's the future because
Yes,
of this
that's the future,
missing
yes.
dockets.
Yeah, yes, I just want to ask something exactly on the missing of dockets. Are they allowed to take statements from me in an event that the docket got lost, can they retake it?
Avela, please, you are interrupting us. Please mute. Thank you. Yes, proceed, Alpheus.
Yes, I was asking if the docket gets lost, are they allowed to retake statements?
Yes,
or
they
if
are.
it is lost, it's lost.
No, they
Oh,
do
okay.
retake. They do retake all the time. Sometimes they do that all the time. As long as the witnesses are still alive and willing to cooperate with them, they do that.
All right. No, thank you.
Just a quick question, ma'am.
Yes.
I just wanted to ask, in an instance where bail is denied or it's set so high that the accused cannot pay it.
We are coming to that. I'm stopping you. It's in the bail part. Sorry, ne? But I know.
I was going to speak to the docket issue, though.
At the bail stage, you don't have access, even the bail if it's refused. But it's fine. Ask your question anyway. I hope you're not going to irritate everyone.
No, I just want to understand. Are there time frames as to how long an investigation can continue up until?
I'm also coming to that. Not so long. Yeah,
no
let's
problem.
move along so that I can quickly answer your questions.
Ma'am, I just want to find out, Francis here. I need to find out, let alone obtaining a document, a docket from the prosecutor. Is a lawyer allowed to obtain a document from a docket from the investigation officer from that particular police station?
No. You apply for the copies of the docket from the prosecutors at court. Because remember, the investigating officer can just inform you if you want to know. You can, there's a part where I'm going to tell you about what you can divulge to them and what they can help you with as investigators. I think it's the next slide where we are dealing with the participants, the relationship of the state officials. It's there. So, but you are not, please, going to approach them and say, I want a copy of this statement. You get that from the prosecutor's office. Right. Thank you. Let's move on, ladies and gentlemen. Okay. The right to be brought before court within 48 hours. It's a speedy production of accused persons from the time they're arrested and detained and actually made to stand before court for their first appearance. That's what we're talking about. So please, I'm not going to waste too much time on this. If you want to know the technicalities of how they count the 48 hours, your manual is there to give you guidance about public holidays and those long weekends which make this 48 hours to actually be expanded. There are instances where the 48 hours can actually be expanded by public holidays like long weekend on a Friday that falls also on a Monday. So, but the point is that this is a well-established right, and in practice, generally, and I've seen that even from the prosecutors to the police, I've actually seen memos going around to make sure that they are well aware on that issue of 48 hours, because in the past, it was quite an issue where people were being brought before court after these 48 hours, and then the issue of unlawful detention would become an issue. But because of communication between the state and the prosecutors, lots of training being given to the police, they do their best to ensure that they comply. I'm not saying that there are no exceptions where they may fall outside the 48 hours. And when they actually do happen to bring an accused before court outside of that 48 hours, remember when the police come to court, before the matter goes to the magistrate in court, it first starts in the prosecutor's office. They are going to be given a tough time by the stationed prosecutor there at court to know why didn't you bring this person before the court within time. And that is where at that stage, if it's found that they were unreasonable in making that delay of bringing them to court timeously, the prosecutors can take a decision not to even place that matter on the roll. So I think that is clear. You want to read more?
Does it also apply in periodical courts?
I know that
periodical courts.
I'm talking about the court of first instance, first appearances. That's normally in the lower courts. So a periodical, I don't know if maybe I am, but the way I know, can you call the word?
Periodical.
Yes, they are mostly used, right, in high court matters where it would sit for a particular time to just deal with, unless if maybe in your area, because I'm in the city, so maybe you can enlighten us. But here I'm talking about.
Well, I'm coming from an era where the court sits on Mondays, Wednesdays, and Fridays. So that's why I'm asking about the issue of periodical courts, if it does, work even there. Is there any excuse that can be advanced with regard to the fact that the court was not sitting today, is sitting tomorrow, and then it's outside 48 hours?
Yes. There an extension will be allowed.
Oh, okay.
Sorry, may I please ask?
Ma'am, can I ask? Hello, ma'am, can I ask? Hello?
Okay. Sorry, ladies and gentlemen. You know, when you are at home, the little ones, they interrupt here and there. But I hope you get the gist of, yes, the 48 hours, there are instances where it can be reasonably extended. And then you can still place that matter on the roll. So it wouldn't be a case for unlawful detention. Okay.
Ma'am, can I ask?
Yes, yes.
Ma'am, what would the impact be on the case if the accused is taken to court after 48 hours, unreasonably so?
You sue the state. Unlawful detention. Yes.
Okay, thank you.
May I please just follow up on that? So,
yes,
you've got the right to sue the state, but what impact does it have on the bearing or any bearing on the merits of the particular charges themselves as a procedural issue? How would it impact the merits of the particular charges that were brought forward?
Look, if the accused was brought before court, when you sue the state for unlawful arrest and detention, it's a civil claim. Now, when you have a criminal case, and it's a sound criminal case that is having, like the state has a good case to go on, that's a criminal matter. So they will be able to proceed with that one. And if the accused is proven to have been guilty, then, that's for the court to make that determination.
So if I understand you correctly, what you're saying is after the release of the accused, because
you
of
pursue
the
a civil
arrest,
claim while the criminal case is still ongoing.
Yes, so they can arrest the accused again and make sure that they comply with this particular rule of 48 hours. Okay, thank you.
Yes. So normally what I've seen actually the prosecutors doing, like when they say, no, I'm not going to place this matter on the roll, they even give them an immediate instruction to go to the holding cells and let that person go and do their work properly. So that's immediately, because remember, if they proceed to go on with a detention, we are talking about detention, not criminal charge, right? And it's now it's not only the police who are going to be a party to the civil claim. Even the prosecutor will be added on to say, you saw that this was already after the time that is allowed, and you proceeded. Now, when you are dealing with a civil claim, you have to also show the issue of was there any failure on the prosecutors to have made that judgment call, because that is their job. That is why cases are brought to them before they are placed on the roll, for them to see whether there is a case for them to proceed and pick up on these issues. Now, and also, is there any malice on the part of the state officials to have further kept this person detained, even though they knew that this is already an unlawful detention? That's a whole other civil claim that you'd have to pursue. Okay. So this goes hand in hand then from the fact that we are expecting that the people will be brought speedily to court. And I think this will answer some of the earlier questions that we got, that the accused also has a right to a speedy trial. Now, in court, you would often hear when the prosecutors are asking for remands on top of remands, postponement after postponement, and they're saying our investigations are not complete, whatever they still need to do. This matter is not getting to trial. The defense would jump and say they are objecting to the court granting further postponements of the case, and they will often use those quoted words by this very wise person who once said that justice delayed is justice denied. So, because we want to avoid any delays and any unnecessary postponements of cases, because those kind of remands, if they are continually allowed, they clog up the court roll. Now, just for your information, in the lower courts, there's time frames for cases to be enrolled. When the prosecutor now takes a decision, okay, I'm placing this matter on the roll. When they do that, they allocate a case number for the court and a court where this matter is going to appear for first appearance. From that moment, we start counting. For the district court, it is expected that that matter must be finalized. When I say finalized, from first appearance to a trial having taken place, if it went to trial, and judgment, it must have happened within 6 months for district court. Regional court, they extend it to 9 months. High court, they go timeframes, they keep it within 1 year, because, but it doesn't have to be 6 months that you will allow. So as early as possible, the idea is to try and finalize the cases that are there. Now, once these time frames that are set have been exceeded, the presiding officers have, on a monthly basis, they have to give a report why this matter is lying pending on their roll and it's not been finalized. So that is not a nice exercise for them to do. They also, they find it very tedious to call for all the charge sheets on there, because that sometimes you may find one courtroom is sitting with pending matters reaching up to 300. So you have to call for all those 300 charge sheets, cipher from them which matters are now exceeding the target. And now you have to now go through each and every one to see. And now you compile a report on each and every one. So it's not a nice thing. So, but the idea is that we try from all fronts, whether it's the state, the defense, and the presiding officers, to try and work towards speedy resolution of the cases. So here, that is why it is important for you as the defense lawyer to ensure that you are not going to just be a sleeping or an idle person in court, because when you've been paid and you are just justifying your fees, you will be there and jumping around in the courtroom there, opposing those requests for remands. But when you do so, obviously you will state the reasons. Why are you asking the court, to not grant further postponements? Any request that the state will make for a postponement of the matter, they need to give reasons. Why are they still asking after the matter has been postponed 2 or 3 times, for example, for investigations? You need to now probe. What is it that is still outstanding? Sometimes the magistrates, they will do that for you. They will ask, state, what is actually outstanding? What investigations are you still doing? And they will say, no, we still want to interview further state witnesses, or there is this type of evidence that we are, trying to put together, whether it's ballistics or whether it's DNA or whatever. They are given a leeway somehow, depending on the type of charge. The seriousness of the offense also gives them a bit more time, even though you will stand up and raise objections for the remands, for the court to still grant them those postponements. So for your more serious offenses, you may find that even if you are jumping and saying, this is causing a prejudice, to the client, and you will say, what is the prejudice? You will say, every time the accused is being made to come to court, they are not able to go to work, they are losing an income if they are running their own business because they have to close their shop to be in court. Whatever is the prejudice, you will state. You may actually find that the court can grant those postponements. But if you give good reasons in your objection for those remands, you are going to catch the attention of the presiding officer. They will then, seriously actually come back to the prosecutor and say, but you've been given, they will go back even on the record to check the charge sheet, and they will say, no, I see 2, 3, 4 times. No. This matter has been postponed several times, and you've been saying you are doing investigations. What is actually happening? Please, I'm considering not to grant any further, postponement. Tell me why I should grant, one more, and then they have to now substantiate. So it's important for you to raise those objections and propose those requests for remand, so that you may find that actually somebody was just relaxing. It may be on the part of the prosecutors not pressing hard enough on the police to follow up, with them to ensure that whatever instructions they're giving to the police, they are actually following their instructions to obtain whatever they need. So it presses them. And sometimes you may find that they will actually, bend and say, okay, we are withdrawing our application for this postponement. Therefore, the court can, have the matter set down for trial, because if there's no reason, there's no possibility of them getting to finality of their investigations, it can't go on perpetually. At some point, it has to stop. So I've stated there, you stress, that this case, obviously, it's pending. Now it's hanging over your client's neck or over their head, that, they can't have peace and sleep. And always they have to remember that, oh God, there's limitations, even, maybe with job prospects, if maybe they're applying for work, this becomes a hindrance when they are now interviewed and they are asked any pending, any charges, and they have to disclose, no, I actually have a criminal case. So the implications of having a pending case hanging over your head, they can be, so far reaching. So you need to ensure that the court is always reminded that they don't just willy-nilly allow postponements. Okay.
Ma'am, just
Yes.
to add on that, some of the reason to remand or to postpone the case can be because of load shedding, because some trial needs to be recorded. Just to add on.
Yes, that one I think it's affecting everyone. So I think that one is a justified. But I mean I know that in the lower courts there were some brave magistrates who would actually, you know, actually proceed with the trial. It's allowed for them to proceed. There is no law that says they can't proceed by what they call longhand, where everyone is making their notes. So the presiding officer will make notes. So basically the proceedings are not mechanically recorded. But that's in district courts for less serious offenses. But because of the fact that, you know, there's always a possibility that this matter can go for an appeal or a review, the practice in most instances is that the presiding officers are reluctant to proceed with longhand. But please don't be surprised if you find that they proceed with the proceedings without using those mechanical recordings.
Sorry, ma'am. I just wanted to find out. You find that a person is arrested for drunken driving, right? So they take them in. So they are there, they're detained for like 2 days, and then they said that they can only be called once the blood tests have been received. I've seen so many of those instances where people wait about 3 years or 4 years for their blood test to be returned. In that instance, how is it dealt with in that instance?
But the blood must be drawn within 2 hours and they will get a reading from a nearest hospital. I don't know if in the rurals, honestly, I don't want to tie my neck because I know if it's in the cities, if they stop you on the road, within 2 hours, they will run to the nearest health institution, which is normally a clinic or a hospital, and get the blood drawn and get a reading of the amount of alcohol that is present so that they can decide whether they are finding that the person is exceeding the legal limit.
No, that's not how it's done. Usually what they do is that they test them with that machine that says that they're over the limit, and then they draw blood, but then they said that we're going to have to wait for the lab to process it, and we will call you. You will only be called for trial once the results have came back for the lab, and it can take up to 3 years. So I don't know. I just, maybe someone in the group can.
So you allow the matter to remain in court on the roll for 3 years. Your time keeps coming for 3 years.
No, they don't come as such. They say the police says that we will call you as soon as your blood test is back from the lab.
Okay, so they don't charge you. You mean?
Yeah, but you are in. They take your fingerprints. They hold you for a night or so while they are taking your blood and everything and your fingerprints, and then they release you. You pay about 1,000 rand bail, then they release you. So once they release you, they say that the only time that you can come to court and see the judge is when we've received the actual blood test from the results from the lab. So you find that it can take up to 3 years, and during that time, obviously, let's say you're putting in an application, you have to disclose that there is a pending sort of like case. So I don't know how is that dealt with.
But to me, what you're explaining, it doesn't sound like it's a case is pending if the accused has appeared in court for what we call a first appearance in front of a magistrate, where they are going to be told their rights for the first time, and they will be told, this is your first appearance, you are appearing in this court on a charge of this, and you can elect now your rights regarding legal representation, whether you will talk for yourself or you will get your own attorney at your own expense, or you will be taking the legal services of a legal aid. Now they elect, and then now the court will entertain the issue of a release in terms of bail or whatever. So if it's just the police on the street, there was no charge sheet where the prosecutor actually placed the matter on the roll, that does not count as a pending case. It only counts as a pending case if it's in the court books, remains open on the court books.
Okay.
Yes.
Thank
So
you.
that one is the police, they do that. Like for instance, sometimes if it's an incident of a house robbery and the police are called by the victims and they come and they take statements from the victims of that offense, and they will be told by the victims that we were not able to see the robbers because they were covering their faces, but we can only tell you what they did to us and only what they took. So the police don't have a lead immediately there to know who is going to be charged. So they will now do what they would clean the scene and obtain fingerprints if they can. So if they can actually, make out from the fingerprints, then an identification can be done. Maybe one day somewhere, this person is arrested for fighting with his wife. It's not even robbery. And
if I can clear the one on drunken driving, because I'm a bit familiar with it.
Okay, so let me finish on this one. Okay. Now, when this person who's fought with his wife, it was a domestic issue and police were called, and then the wife actually says, no, he beat me, I'm opening a case of assault. Now it ends up with this person now being arrested for the assault of this wife. Obviously, every accused person, fingerprints are taken. Now the police have a system where they keep a record of potential fingerprints picked up from different crime scenes, and they make a match out of this person who was beating his wife to say, no, these same fingerprints were found in a house where there was a house robbery. Now they can now say to the accused at a later stage, not only are we charging you with assault of your wife, you are linked through your fingerprints to the robbery. So that is how the cases in the police hands can stay open, pending, because they are still under investigation. They never actually have a face or a name to put and say this is the robber. But at a later stage, they now have someone to link. And now that case removed from the police pending records, they bring it into the court now to say, okay, add this charge. I hope that's clear. All right.
Okay.
Okay.
Well, ma'am, it's true what the lady say. My colleagues says that when a suspect is arrested, they released on immediate bail at the police station 1,000, and are given a court date for first appearance.
But she said, but she said that they don't appear in court on those 3 years.
I think she was a bit exaggerating the number, because it does happen sometimes that you wait a number of years, but you do have a first appearance on within 48 hours, which is the Monday, if it was the weekend, the Monday, or whichever the 48 hours that you were spoken about before, you do get the first appearance. Then after this first appearance, you are told, you're given a date to come back on a certain time, which sometimes is more than 6 months. That is caused by the backlog in government what you call labs. Yes. Yeah. That's normally is the issue. It's not something that the police are pushing the matter to go on for years and years. It's just if the government laboratories have not done the test, it keeps getting postponed, because the evidence of the breathalyzer and the what you call this, the physical appearance, is not enough to convict a person for drunken driving. They have to have the blood test. I think that's what the lady was trying. Yeah.
Okay, I get you. So if that happens, then it's actually on the court roll. Then if they do actually place it, then the accused will then have to go and answer the case in court. It's for you to challenge. If you say you were not drunk, or it depends on the instructions that you will get from the accused. You can obviously, depending on your strategy, also challenge the that evidence based on what we call technicalities, because it's a statutory offense, what you are talking about. So the chain of custody will be an issue to know from like 6 months ago when that blood was drawn, where has it been all along? So if there's any suggestion of any interference or tampering with the samples, then it's an issue for trial.
But
then you'll go and fight it out in the trials. So, but the idea, please, let's not lose track, ladies and gentlemen. I'm just telling you that any unnecessary request that you feel that this is unnecessary, a delay in getting the matter to trial, you will raise your objections, and with reasons. The state also can also, say the same, that you as the defense, you are causing, delays, because every time you come to court, no, your worship, we're still consulting, we're still checking on, further defense witnesses. We are going to ask the matter to be. So the coin it applies the same on both sides of the coin. Both the state and the defense should not be causing delays. And both the state, as much as the defense, can oppose a request for a postponement. That's the gist of what I'm talking about here. Okay.
Question.
Hello, ma'am, can I ask?
Hello, can I ask something?
Last one on this issue.
Yes. Because if your client is denied bail, can you hear me?
Yes.
Yes. If your client is denied bail and therefore the prosecutor is postponing the matter pending further investigation, at what point can you reapply for bail?
At any stage, I'll come to that when we are dealing with bails. Hold that question, eh?
Right.
Thank you. Okay, so basically, I'm summarizing, like I said, ladies and gentlemen, there are many rights, and I'm not gonna. You see how much time we took on just these few rights. So please take time as the legal representative to acquaint yourself with all these rights. See when you will need to, to actually, raise those rights on behalf of your client, so that you are knowing when, a right is being violated, and you will be able to ensure that your client's rights are not being tampered with. I'm moving away from the rights. Please give me a second. I just want to switch the lights on. So, ladies and gentlemen, we are moving now to the relations between the state officials. And because I've touched on most of them, I think we will move also much quicker on these different state officials that are involved in a criminal case. I've already mentioned that the investigating officer is there, and it is important with a criminal case, when you come on as the defense attorney, to immediately establish who is the investigating officer. This is the one officer who's going to have, first of all, the docket. Most of the time, they even keep it with them after hours. So if you want to know more information regarding the charges, if it's at the police station or even during investigation stage, the investigating officer is the officer that you need to know, and you can, here and there, liaise with them. And should you have any problems with how they are conducting themselves, like the example given by one of you regarding the manner that the cases are handled on behalf of complainants, you can bring that to the attention of what is known as a station commander, because that is the officer that is in charge of ensuring that the investigating officers are actually doing what they're supposed to do. Any complaints, any problems, any delays with them bringing the dockets to court can be communicated to the station commander. They are the ones who know where to find them sometimes when you can't reach them. So they are the ones who can instruct them, even if they are coming from far off, that take the docket to court now. And so it depends on each and every, but every police station has one stationed commander that is going to be in charge. Now, like I said,
Ma'am, can I ask one question?
Yes.
We have seen cases where, I say, for instance, a person is involved in domestic violence conduct, and maybe someone is assaulted or whatever the case may be, that forms the fact of the case. And this person opens a case at the police station. It happens as the accused or maybe the suspect as arrested, and later on the investigation officer, I'm just giving you an analogy here, the investigation officer engaged in some kind of like bribery or whatever with the suspect, and then the case was thrown out. How do you handle that kind of a case if you're called as a legal representative to the complainant?
If it's the complainant who's complaining about the conduct of the investigating officer taking bribes, they must report that to the seniors of that investigating officer, starting from the station commander. There's the independent policing, whatever, if that station commander also doesn't. So they can also follow, you know, the hierarchy within the police force to ensure that that police officer is being investigated for this bribery that you're talking about and corruption, maybe even a criminal charge that can be made against that investigating officer.
All right, thank you, ma'am.
Yeah. So they know, as I've indicated, that these are the investigations that are being conducted. If they are forensic, if it's ballistics, if it's fingerprints, they are able to tell you exactly what kind of investigations they are doing, and they would know even the witnesses, obviously the eyewitnesses. So without obviously you know, interfering with how they run the investigations, but it may be helpful, especially when you want to apply for the bail, to be at least acquainted with the type of case that the accused is facing. Because remember, at this stage, you are not having a right to the docket. So they can give you some light, not all, but some light. And they are the ones who, when you are bringing your bail application, they will be now standing in court or writing that affidavit to the court to say they are opposing your application for bail, or if they are not opposing, they will give reasons also why they're not. So that is why you need to get to know who they are. Sunrise, do you want to say something, or it's a mistake that your hand is up? Okay, Sunrise hand is off. So I think it's clear, ladies and gentlemen, that if the client is being kept in custody, you discuss about issues concerning bail, and you can also find out the reasons why they are going to oppose. And maybe you may actually bring some information to them to inform this investigator that no, there is this information that will sway you, not in an unfair way, but it will now actually change. It will, Ignatius, you're on. It will change your attitude to opposing bail. So if you have information that you want to divulge to the investigating officer, you obviously have to inform your client and get their permission that, okay, you can go ahead and disclose that information. That will be helpful in obviously this investigating officer now making a stance whether they are going to still oppose, or now when they get that information, because they can follow it up on their own. You just maybe just give them a lead and say, please check on this. And because they are investigating officers, they will access whatever information that you give them. And from that information, they may actually come back and say, no, because of this information now, we are not going to oppose the application for bail. Always keep in mind the best interest of the client, that it's important for you to keep a good working relationship with the investigating officer. But please be careful not to disclose something that can be potentially prejudicial to the client. Because this person is a police officer, he's not a defense witness. You may mention something to them that can actually open up and expose the accused and lead to them actually getting into more trouble. So you be careful with what you say to them and information that you are divulging to them, that it mustn't be to the detriment of your client. I think that is clear. So it's a balancing act. You'll just make a judgment decision there, whether you are telling them or what. But always remember, they are state witnesses, but they can be useful to help you. And they do actually, where they find that there is no cause for them to oppose, they will actually inform the court that they are not opposing the bails. Prosecutor is our next state official. I've discussed it at length that they are dominus litis. They are powers to decide on matters to prosecute or not to prosecute, powers to withdraw cases. It's something we've discussed already, so I'm not going to dwell on them, but I'm just mentioning them as by the way. Then you have your clerk of the court or the registrar of the High Court. Their role is purely administrative. That's where you will go if, for instance, you want to get a copy of the charge sheet to know the charges, or you want to apply for a bail, you will go to them and request for them to draw the charge sheet and take it to a particular court where you want to bring your bail application. And if the court has granted your bail application, you will go to them to make a payment. Okay, here, please, remember you are lawyers. You don't get involved with that part of paying bills for your clients, but you can accompany maybe a family member to show them, here's the office of the clerk of the court, go and pay the bill there. And if maybe there's a fine or after a sentence was passed, where now they can go and pay a fine. So they are responsible for the safekeeping of the charge sheets and all the criminal record books. The court books are kept in their custody. They also receive requisitions requisition forms where you want an accused who is kept in custody to be brought to court, and the matter has already been postponed to a future date, which is too far. I've noted you to Lasizwe, where the date seems to be far and you would like the matter to be brought forward. Maybe you want to entertain an issue of bail. Then you will go there and submit those forms to them. They receive your applications where you want to make an appeal or reviews or request for record of the proceedings, that is transcripts. So that is purely an administrative task. I mentioned also, just here, one line, another participant in the criminal courts is what is known as interpreters. And I say you need to be wary of incorrect interpretation. Now, okay, before I go on that one, let's hear Thulasizwe. Thulasizwe, I've said if you want to speak, please say your say, unless if you are playing with the buttons. So I'll ignore the hands that are up. So in most of the
question.
Yes.
What happens when the accused is not able to pay the full amount, the fine, at the instant when they are given a fine?
We'll come to the different sentencing options at a later stage after we've dealt with the trials. So we'll touch also on what you can do to address that issue at the sentencing stage. So we can hold that. You can maybe just note it, and if you see that I'm not getting to answer you exactly, you can bring it up again there. Ne? Okay, so
yes, ma'am.
Thank you. So most courts are using what is known as interpreters because in most instances, most accused persons are what are said to be unsophisticated and learned, so they may not even be able to express themselves in English in most, which is the language that is used in most courts. So you may find that they speak any of the local languages here in South Africa, or they may be foreign nationals, as you know that we have a lot of them in the country, and a lot of them obviously being accused persons. So please, wherever possible, I know that we can't all know all the languages, seeing that South Africa have so many languages, but it helps if you are someone who is conversant in, or rather multilingual, because you don't even have to know how to write, but at least if you can hear the language, pay attention when the interpreter is taking the information from your client who's speaking some vernac, whether it's Sotunguni, Venda, Shangan. When they are speaking, if you can, you are familiar with that language, don't just listen and pay attention only when they are interpreting in English to their presiding officer. Listen to your own, or the witness that is testifying in this language that you are conversant in, and ensure that you'll be able to pick up if there's something wrong in the interpretation, because in these interpreters, they are human beings. Whenever there's human beings involved, there's always room for human error. So it may not be that they deliberately, are misleading in the manner in which they are interpreting. So it may be actually just purely a mistake. But if you don't pick it up, it may actually have a very, very, detrimental effect in terms of how it is relayed to the court if it is not meant to be said in that way. And now remember, most of, if also the presiding officer, it doesn't know the language spoken, and they are also only relying on the English that is being translated to them, then even when the accused now is being attacked and they will say, no, this is not what I mean. If you missed out on that incorrect interpretation, it will now actually lead to a situation where the accused is being made to look as if they are inconsistent with their testimony, or they are changing their story, or you understand. So it's very important that if you understand the language, if you can pick up on the spot, interrupt that interpretation and say, when they're saying it in English, no, Your Worship, please pardon me, but that is not what the witness is saying. Can the interpreter go back to the witness and listen again to what the witness is saying, and try and see whether it will come back the same? In most instances, you may find that the interpretation is being corrected. So if you're missing out on those information, yes, there's lots of case law where cases and people have been convicted, and they will later go and say, that is not what I meant. And, so if that happens, the interpreters, they also have their seniors. If it's a real issue, which is now a crucial issue in the case, you may even stop the proceedings and get.
Ma'am, can I ask?
Yes, but I'm still gonna just finish this issue. You can interrupt, you can come back now. You can interrupt the proceedings and ask that maybe a senior of that interpreter, if you find that they are still not getting it right, come and listen on the recording to see whether their interpreter in court is relaying the message correctly. And if they are found to be making a mistake, their senior will say, no, there was a mistake and it will be corrected. That is the advantage of being multilingual and picking it up. But unfortunately, there are those languages that we just all don't know. And especially this happens a lot with foreign nationals, that they will speak a language that we as South Africans may not be conversant and even have a clue of what they're saying. Sometimes you'll see that the interpreter is going back and forth with the witness when they are just supposed to just hear what the witness is saying and relay the message to the court. When you pick up that is happening, interrupt and say, I see that the witness, instead of telling the court what the witness is saying, there's a back and forth between them. That can lead to a missing out of crucial information that needs to be brought to the attention of the court. And also the demeanor of the interpreter, because, most people are not used to a court setup, because the courtrooms, as we know, they are very cold and unwelcoming and intimidating. That's why you need to do a proper preparation of your witness, to tell them and show them, if possible, and let them know of the people that are going to be there in court. If you see that, this interpreter is being a bit forceful on the witness, even though you don't hear the language, interrupt and say, I see that it looks like there's a misunderstanding between the interpreter and the witness. Can we just make sure that there's no misunderstandings, because an issue of incorrect interpretation is very serious, ladies and gentlemen. Okay. Yes, there was someone who wanted to talk.
Oh, it was concerning what you're saying, ma'am. How do you interrupt in a respectful way? What do you say? What do you say to the court? Do you just stand up and say, no, what you're saying is wrong? Or what words, what choice of words are you supposed to use?
Pardon me, Your Worship. I'm picking up that there's a back and forth between the interpreter and or you can even say, Your Worship, I'm sorry to interrupt. That is purely simple English. I'm sorry to interrupt. And I see that, there's a back and forth between, we don't want to miss anything that may be important that is said by the witness between this back and forth. Can we just be clear that they are understanding each other?
Thank you, Elsie. Can I just interrupt you?
Yes.
Can we have our 10-minute break, please?
Thank you so much. Yes. So we start 7:45, ladies and gentlemen. Let's take our walkabout and bathroom, whatever you need to do. Thank you. We'll pause here. Ne? Okay, we are back. Do we have any questions before I leave this slide, ladies and gentlemen? One, two.
Proceed.
Thank you.
Now
Madam,
yeah, just before you proceed, I'm not sure if it's my device or not, but what I'm seeing from my screen, it says the content cannot be displayed. I'm wondering if everybody else has the same issue. So, yeah, I can't see the slides. Yeah.
Okay.
So the slides were on slide 28 of 35.
Okay, so I think it's your device. Yeah, it's your device. Maybe restart it and then join us back again. Okay. Amasha, do you have anything? Or are we talking to Amasha? I don't know. Okay. Ladies and gentlemen, we are moving now to another part of remember, we are still pre-trialing. And this is the part where we deal with investigations. And the first part that we will touch on under investigations is identification. Now, evidence of identity, it may be proved by either direct evidence or circumstantial evidence. So, circumstantial evidence, I give you examples because I see a lot of people, they struggle to make out what would be deemed to be a circumstantial evidence. Examples of fingerprints that are picked up from a crime scene. For example, the case I mentioned of a house robbery, where the victims say, we did not see who robbed us. They can only tell what happened. And the police come, they are able to pick up specimens that are taken for testing, and an identification is able to be made of those fingerprints, and eventually there's a match of those fingerprints to a particular person. So even if those witnesses will not be able to come to court and say, this is the person who robbed us, because then obviously they didn't manage to see them, that fingerprints will then be used as evidence to link them to being present at that house. Handwriting is another example where you would obviously make use of experts who would do comparisons of the different handwritings. Shoe prints, same way, you would use experts as well. DNA, like blood samples, hair, semen, body fluids, they can be used to do an analysis, and then they will be able to give out a report. And if, for example, which is popular in rape cases, where maybe the accused will be saying, I'm not the one who raped, then the state is reliant of a single witness who is the complainant. And she says, I didn't see the person who raped me because it was dark. Now, these samplings that are taken from the body of the victim and the accused person will be now analyzed and a report compiled, and that if there's a match, they can produce that as what is called a circumstantial evidence. Please, it's not a conclusive list. I'm just giving you examples to show what stands as circumstantial evidence. And based on that circumstantial evidence, if it is conclusive, it cannot be challenged before the court. It cannot be discredited in how it was, the analysis was done or the comparisons was undertaken. If that cannot be discredited, that evidence will stand and the court can convict solely based on that type of evidence. Now, your direct evidence will be a testimony of a witness who says, I am able to identify the person who attacked me because I saw them. So they can do that in different ways. They can immediately identify their attacker or assailant immediately at the scene of the crime, or that identification can take place at a later stage where the accused has already been arrested and the witnesses will be called upon to come and make an identification of the suspects. Now, this direct evidence of identity, just like any type of evidence, even if it's direct, because this person says, I saw X doing this to me or doing this to whoever, it's always going to be treated with caution. And the same caution that is applied to evidence of this testimony of this direct or eyewitness, whatever you want to call them, or the complainant themselves, the court will treat it with caution because, you know, people make mistakes, and whatever the circumstances surrounding how this identification was made, it will be tested to check that there's no possibility of them making a mistake. And the same caution can also, because in general, you know, there's and can I say perception that if you are dealing with one of these circumstantial evidence that I have mentioned, it's very difficult to challenge it. But please, because I talk to you as a defense lawyer, and we are at this practical PVT, as it's called, I don't know, but you are expected that in future you will be defense lawyers. So we put in our defense lawyering caps. Whatever is presented before us, we do not just take it as it comes. That is why you are going to be given those reports that have been compiled as evidence before the trial starts, for you to go and sit and do your own assessment, or whether that evidence was properly, obtained, and the analysis, the way it was done, and you can make up your mind. If you see discrepancies or something that you can challenge, then here we are talking about, for instance, with DNA, where now a chain of custody will be a huge issue, where we have to ensure that there was no tampering, if of any way, with that type of evidence. So most of the time, what I'm saying is that most of the time, practitioners, when they are faced with a DNA report that comes and says that it's linking the accused persons, the lawyers tend to shrink and the prosecutor will boast that, no, don't come and waste my time. I've got a positive DNA, you understand? Or I've got positive, my fingerprints analysis, they are positively linking this person as, so yes, on paper, it may look like that is the end of the story. But what I want to say to you is, please remember that those reports, those analysis, those testings, those samples were handled by human beings, not only by machines. And whenever there's a human being that is involved, human error is an issue, is bound to be an issue. So please take time. It may take you a bit longer to acquaint yourself with your case, but I just want you to know that it is not the end. If it comes and it says DNA is positive, now you need to dig deeper, especially where your client says, I was not the one. Just to help you to see, you know of generally, which I don't know how much emphasis you can place on that, but you know, American TV has been showing instances where people were being said to have been linked through just fingerprints and DNAs. They went to trial and they were convicted, and later on, the victim will come and exonerate the person and say they were not the one, or whatever evidence will come out and show that they were not the one. So human error is always an issue to consider whenever you are dealing with that circumstantial evidence. So don't take it as conclusive that it cannot be challenged. You may have to read up a little bit. I don't want to, I know how, I would personally handle it when it's just for another day. For the sake of progress, I want you to keep your minds open to know that even if they are coming with a positive report and they're saying, look, don't waste my time, now you need to dig deeper. And you may actually find something. Okay. So when talking about direct identification, it happens, as I said, by the victim themselves at the scene or later on, being called to what is called an identity parade to come and make an identification of the people who are possibly the ones who committed the crime. Please note, with identity parades, the accused has a right to have their legal representative present during that parade. The legal representative is allowed at this parade to be only an observer. So you don't interfere with police activities. You, as the legal representative, you stand on the side where you've been allocated your place where you stand, and you simply take notes. If you notice something that is noteworthy, something that you would want to bring up at a later stage of the proceedings, and if you may, which is undesirable, that you may actually find yourself wanting to witness, to how that parade was conducted. But the basic thing that you are actually observing here is to check, I'll tell you now, certain things that are happening at this parade, like, okay, like I've said, because of human error, human beings are known to make mistakes. Please take note of that case and see how the courts have found that some gross injustice could possibly be done through a witness who is honest, but it's making a mistake with identification, because generally people were said to often resemble each other, and that is why we have look-alike, So great caution should always be applied. And there are the cases, citations where the courts have said the identity must not just be reliable, it must also be trustworthy. And State versus Muthetwa is a very popular one when you are dealing with evidence of identification, where we are advised that we should guard against a bona fide mistake on identification. It's an honest mistake that people can make. This case of State versus Muthetwa has listed a few factors that we often use to assist us to check on this identification. Prior knowledge of the witness to the accused, the time that they are making their observation of the accused, if it's at if it's in the morning or I mean if it's daylight or whether it's in the night. And you check also how often these people, if they know each other, how often were they seeing each other? Because I can tell you that, well, maybe I have a short memory span, I don't know, but there are people that I grew up with. If I see them, sometimes I'll be like, I know this person, but where do I know them from? I can't even remember their name, but I'll be like, I know this person from somewhere. So you have to check how often, even if they say they know each other, because the level of interaction, if you don't see a person for many years, you are likely to forget them or, you know, things like that. It's normal. And the observation, how long, the time of the day I mentioned, the lighting, the proximity, how far apart from each other were they standing, circumstances of the, is this a moving scene? For instance, with a robbery, you know, it's very fast paced. It's guns pointed out, you know, there's shock, there's, you know, force, you know, violence inflicted on, you know, possible, you know, situation where you can be shot and killed. It is a moving scene. Is this a chase, you know, like a hijacking? Is it the number of perpetrators that are involved? Is it 1, 2, 3? Did you manage to see all of them, you know? And why do you say all of them? What did you pick up about their appearance? It can't just be clothes. It can't just be they were black or they were, you know, brown or they were yellow. You have to give more. The witness has to give reasons why this particular accused is standing out amongst other people if there were many people at the scene. The position of the accused. What role were they playing for them to have taken a particular note of them? Who did the talking? Because sometimes not everyone is talking. Describe also not only this accused, the other perpetrators that have not been arrested. It would help if there is some description also that is given of them. That is based on State versus Muthetwa. It also says, check also, like I mentioned, with violent crimes, there's fear, there's threat, there's an issue of sudden danger. It's, you know, anything can happen. Whatever happens suddenly. You're totally caught unawares. It's unexpected for this to happen. So when and the assailants may pounce, you know, on the witness, and they do not even have an opportunity to compose themselves, sit clearly, take a good look at them, and be able to make out, you know, all that they would ordinarily be able to make out in a comfortable, calm situation. So any other concerns that you can think of, you need to bring them up when you are dealing with evidence of an identification. Their position of the witness. They may tell you that I was pressed down against the floor with a gun behind my head. So it means your movement is restricted. Description also, if the police statement that is given to the police by the witness, it's giving very little information about the description. But when the witness comes to court, you are getting a lot of information regarding the description. You are even getting exceptional features that are mentioned that stand out about the witness. You need to check whether those exceptional features were mentioned to the police. Because if someone has a huge scar that is just running down their cheek, it's something that the witness would most likely remember and mention at the time when they are initially giving the statement to the police. They can't just come maybe 3 years later when the trial is finally ongoing and they come and say he also had a big scar, but you can challenge them if it's not mentioned anywhere in their statement. The type of clothing, it cannot just be mentioned it was black clothes. Black has different shades. If it's clothes, you need to say whether it was jeans, it was cotton, if, give a description of the clothing. Disguises were they used, and give the description of the disguises. Was there a hat? Was there a cap? Was there a face mask, which Corona has made to be so popular now? And the reason why this witness is saying to the police that they suspect the accused is often an issue that you need to check, because sometimes it may be based on information that was given to the police by people surrounding about this accused. So here I'm talking about someone who is popular in the area for being, those street boys who normally break into people's houses. So if the witness comes and says, when I found my house broken into, I immediately suspected that it was the accused and his friends, then the question would be why? No, it's because they are known, to be naughty boys within the community. Something like that, obviously, it's a personal bias. It cannot be made to be something that should hold, a water before the court and persuade the court on the identification to say without a shadow of doubt, this person is the assailant.
Just 2 questions, madam.
Yes.
Yeah, one, how the police identify the people who go for identity parade? And then secondly, how do we deal with cases like okay, let me give you an example of Senzomiwa situation where this guy gets killed in this particular year, and then the case goes for trial at a later stage. So that means that even if one were to identify you, there may also be question in terms, the person, because you age-wise, this person has grown up and all of that. So how do we deal with all of that?
You are on the right track. Those are the factors for the court to consider. So let me just see. There's something I'm going to show you, which I forgot to upload on my PC, but I'll try and see if you can pick up the picture. Let me wrap up here. On this ID parade, we are saying that the police, this is how they do it. They will normally round up, and I'm glad that we have, I'm really hoping, and I've done my own research. I'm not saying I'm the authority on everything, ladies and gentlemen, but with the research that I have done, and it's a common practice. I'm not saying they are wrong for doing so, but I understand for convenience reasons, maybe that may be the reason why. But there's a common practice when it comes to identity parades that when they have to do it, they will round up people who are in the holding cells for convenience, because they don't have to necessarily go out into the community and find people walking on the streets and bring them in. it's a common practice. And please, if you are a police officer, you can also help us. But that is what I have, in most cases, I have seen. That is, I've never met a case where personally from colleagues, as I've asked, that the people will come from outside. I'm not saying it doesn't happen, but the majority of times, the people who are going to be in the lineup are people who are in the holding cells for different cases unrelated to this particular one, where the witnesses are being called to come and make a parade. I mean, to attend the parade. So now, when they are called, the police, they do have a guide in terms of their policing rules. It's not an act like a legislation. It's just a guide of practice, how they conduct the parades. So they use a form. It's like a booklet with a number of pages. Those booklets come in in forms format where words will be filled in, like to say who are the people on the lineup and their names, their ages, race sometimes will be mentioned, age will be mentioned. So, and at the parade, they will be made to stand in a line, and they can be moved around when the different witnesses are coming in to make the parade. And even the suspect, they can ask to be moved, if they were number 2, to move to be number 6, you know. And the only thing is that the suspect will be informed that we are doing an identity parade for your case, right? But if they refuse to be part of the lineup, that will obviously be used against them in court. So it's not advisable for them to refuse, even if the outcome of the identity parade is going to be positive. And that guide of the police, it says that the people on the lineup can be a minimum of 8 persons. So it can be more, but not more than 1 suspect on that lineup for the same case. So let's say the case has 3 suspects. All 3 of them cannot be standing with those 8 people to be making those 8 people. So only 1. So they need to move around the suspects, and yeah, so basically not more than 1 suspect should be on the lineup. And then, what do you, as the observer?
Can I please ask a question?
You are okay. Don't you want me to just finish this and show you the picture? Then you're gonna ask me something that I was gonna say. I'll please give you chance now. Let me finish this slide. Now, at the parade, you as the legal representative, you check on the following: the length. I mean, is it the length? No, a height. Sorry for saying length. The height of the people on the lineup, the build, body build, the appearance, the race, the occupation, the clothing, the dressing, how they are dressed. If it's torn clothes, then the idea is that the appearance of the people of the lineup should look similar. That is the idea. Because why? We are trying to eliminate the possibility of a suggestion and the fact that a witness can make a mistake. So if out of all those people who look almost the same, they dress in the similar way, they almost have the same build and, a similar type of dressing, clothing, appearance, they almost look alike, but the witness is still able to pick the accused out of all those people and positively say this person is the robber, then it is more convincing to say the likelihood of a mistake is diminished. Now the witnesses will be separated, and they will go in one by one. They're not supposed to have any discussions as they're going in and out, so they must be constantly under supervision to make sure that they don't talk to each other. And they, like I said, the lineup can be moved around. The suspect can also ask to be moved around. Now, at the end of the observation made by the witness, they must say whether they identify anyone on the lineup or they can't make any identification. And that will be noted by the officer that is in charge of that parade. Parades will be held out of sight, no entry, no exit during the parades, no witnesses to see the suspects before the parade. And also very important, the person who is running the identity, the officer who is running the identity parade is not supposed to be the investigating officer for obvious reasons. He is obviously, he knows the state witnesses, he knows the accused. So to eliminate those suggestibility issues and influence, it will be done by an independent police officer. And once that is done, they will make their comments to say what was the outcome of that parade. If it was a positive identification, they will so, and they will so say if there was no one pointed out, it will be written down. Then that booklet will be attached to the docket. So when you are given the copies of the docket, you will also be given that. Now, please note, pictures mostly are taken at those parades, and videos also can be taken at the parades, but it's not a hard and fast rule that, if they don't have those, then you can't say there was no proper, parade. And in most instances, if you are lucky enough to be present during the parade, be there so that you are going to be able to pick up on these things. So please let me take your question. I see that we are running out of time. Then I can show you the image that I want to show you quickly.
Yes, ma'am. I just wanted to ask if can an inmate that is pulled into a lineup that is not a suspect, that just forms part of the other 7, or can he refuse to be a part of that or not?
He can. Even the accused can refuse, but it will be mentioned in court that the accused refused. So now it paints him in a negative light.
But it will not be prejudicial to somebody else that's not a suspect.
No, it won't, because they're not part of this case. That is just to assist them to formulate a lineup.
Thank you.
Yeah. So, ladies and gentlemen, most parades, they happen obviously, well, not obviously, they happen without lawyers. But if you pick up a matter at the earliest available opportunity where it's still new, like it's at the arrest, and you are the attorney of record as the matter is building up, please, when you hear that the state is asking the matter to be postponed for the identity parade to be held, ensure that you are going to talk to that prosecutor to get the details, the time, and where that parade will take place so that you can be present. Please take a look at this. I told you that I hope you'll be able to see. It's not so good here. Do my best. See. This is the typical the photos that are taken at an identity parade are going to be in black and white. Ne? And there are instances where you may find that they're in color. that's when you are lucky. Now, what I'm showing you, I'm sorry I didn't have time to scan this into my computer. I just wanted to show you. I hope it's close enough for you to see. The people on the lineup. First thing that you can obviously see from the pictures, they are wearing different types of clothes. They are wearing different colors, you know, and even their body build is different. So I can tell you from this case, their identity was positive, but this parade, it was challenged. So normally when they, oh God, yeah, this one is too close. I don't want to be blamed for having exposed it. This one is better because it's darker. The one who was pointed out was said to stand in front of the lineup, you see, and then the others are at the back. So now, what are you doing when you look at these pictures? When you get them on the docket, you are going to try and show the court, because these photos will be presented to the court. What you are trying to show the court is that if your client was the tallest guy on the lineup or was the shortest guy, you have to check, ladies and gentlemen, things like hairstyles. From the pictures, you can make out that there are some who have dreadlocks, some who are looking like their heads are shaven, clean. Some, they do have like short hair. So things like that, they need to be, you need to basically know your client very well, look at them very well, and see whether they were not the ones who were looking like the one who stands out because of a particular feature on their body. So I wanted to go back to this.
Elsie, quick question, Elsie.
On this case, for example, guys, the guy who was pointed out, he was wearing a tracksuit top, but the others were wearing t-shirts. And it might have matched the color, or, you know, that was mentioned by the witnesses. You need to check. So please, the idea is pay attention. I don't know how much I can say on this. So let me hear you. I hope you get me.
A question. When in an event there's a positive identification of the suspect, but forensical, no. Let me say, in an event that the complainant does not identify the suspect,
at the parade.
But forensical, I'm saying yes.
At the parade,
the complainant is, yes, at the identification parade.
Yeah.
Then the complainant is unable to identify the actual suspect. However, forensical, then like they picked up the fingerprints. What impact will it have when it comes to court a matter of that nature?
Then you have to ask your client, why was your fingerprints found at the home of this witness? Do you know each other? Have you ever been there? And if yes, what is your relationship? What led you to be there on that day? Then they will have to tell you. Then that will be your explanation why his fingerprints was found there. But if they don't know each other, yeah.
All right, no, thanks.
Okay. So
a question.
Yes, Godfrey.
I want to establish
if the success or failure of identification has got any material effect on the outcome of the trial.
If it is positive identification at the parade,
yes,
and you don't challenge it at all, then it means you are agreeing with the state that the witness was pointing correctly at the accused as the assailant who attacked them on the day of the incident.
Yes.
But if the accused gives you instructions that, no, I wasn't there, I don't know these people, I've never even gone anywhere near there, then that's when you will, like, your defense is completely a bare denial. That I don't know these people, I wasn't found with anything that's linking me to this crime, I have never been even to that place, I'm just unlucky, they just pick me up and they are connecting me to this crime. Then that's when you need to get to the bottom of this identification, if it is positive, to establish that, you know, because, and also when you're looking at that report of the positive identity parade, you have to go back to the initial statement that was given by that witness. Now, if at or shortly after the crimes, the incident had just happened, police were called, and shortly thereafter they went and they gave statements to the police. Check how much detail was given about the assailants. If there's little information, all they could just say was that they had guns, they were wearing dark clothes, and then all of a sudden this person is able to make a positive identification at the parade. Now you're going to dig deeper how coincidentally there was no description at all that was given to the police that could have helped them to keep this memory of this person, so that when they see them on the lineup, they can quickly remember them. So it doesn't mean that the witnesses are always wrong, but like I said, those cases that I mentioned, they show you that there's what is called lookalike, you know, and people do genuinely make mistakes. It's not that they are being malicious, and, you know, so you have to just work on getting to the root of why, you know, this person is not the one, not why they are being positively identified, and show the court that, no, this witness is making a mistake. It cannot be.
If the accused is able to show that on the date in question, he was not even around that particular situation, was away, then what will become of this positive identification?
Then you look at the circumstances surrounding the lineup. Because if he's the most ugly looking, because, you know, I'm sorry to say, there are people who just look scary sometimes when you look at them. It's personal bias. Like when you just look at them, you just make your personal conclusions about them. And you're like, hey, this one is looking like, I'm sorry, like it's OT or whatever. You know, I'm not saying it's right. That is why we are here, to uproot those biases. And, you know, if he stood out as the one who looked the most like a gunman or whoever, you know, that is common in our communities. And that could be the reason why they are pointed out, you know. And he looked like the one who is likely to be the terrorist. Then you get to the root. But know your client. If he had the hugest nose on the lineup and say, no, all these people, they have very small noses. This one had something that made him stand out. That is why he's being picked on. That would be your argument.
Elsie, a quick question.
Yes, Petri.
On the lineup, and when the photos or videos are taken, is there any consent that needs to be given by the people in the lineup for those photos to be processed in accordance with the POPI Act?
Yeah, that's something else now.
Yes, it's a bit off topic, but yeah, just briefly, is it a requirement
But
for?
this person is, the police will say this person is a suspect in a criminal investigation. So we are not doing this to violate their privacy. And these pictures, even as much as I've been showing you, like you can see, even me, I'm trying not to get myself into trouble. But the idea is to show you. But then remember, the docket is meant to be, these photos are meant to be shared with you, the lawyer. And you, the lawyer, you're not expected to broadcast them on your Facebook page. So
Okay, sure.
I think the safety or the protection there would not be an issue. So the police, I think also, it's helping you. Why would you say no? Because in most instances, when these parades happen, lawyers are not present. So it's actually helping you to get a clear picture of what happened there. And your client might not be so, he might not have thought about all these things. And only when you look at the pictures, then you can question him and you can get more information there. And he can tell you that, yes, all these people didn't have dreadlocks. I'm the only one who had dreadlocks. Everybody had clean shaven hair or short hair, and everybody, because these pictures will be, the state will be very proud that they had a positive identification. You don't object when they want to hand them up to the court as exhibit. You allow the presiding officer to see them so that you can make your argument and say, look at the pictures. This person is the only one who is standing out differently from everyone else. That is why we are saying he was being picked on. So it helps you. Okay.
Thank you.
Ma'am Elsie.
Okay.
Yes. Yeah, if I just may take you back a bit on the circumstantial evidence aspect of your presentation. Now, say a scenario, there has been some sort of planting of evidence. In the case, for an example, someone stole my shoes and took my clothing items, or may have cut my hair and placed it on the scene. And police happen to discover that. Now, my question is, where does that put your client in terms of discrediting such, quality of evidence? And then, say, perhaps you have an alibi that you were not present at that particular location, but there's quite a few number of items pointing to your presence in that placing you there, basically. So what will happen in such a case to your client, and you know that perhaps the client was not there because there is an alibi?
You don't know. You don't know. You were not there. We are hearing from our clients. So if the police have circumstantial evidence that is found at the scene of the crime, your first question to the client is, they found your hair in the house of the complainant. Tell us how it got there. And if he says I was planted, then you have to show the motive. Who would go out of their way to cut somebody's hair, go and plant it in a crime scene? What reason do they have to do that? And the trouble to go through that. So you see, it looks far-fetched. You cannot come with an explanation which is highly unlikely before the court. Your client must give you an explanation that is reasonably, possibly true. We are not talking fantasies here. You also sometimes may need to put your foot down and tell your client, don't bullshit me, because I'm going to be challenged with this evidence and I have to stand and, I cannot fight a losing battle just because you decided to just abuse my, it's your integrity as well and your reputation at the end of the day. So, ladies and gentlemen, we are out of our time. I see that we moved better. I'm not concerned. We still have...
Yeah, Elsie, and don't embarrass me in court.
No, I can never. I'm on your side. We are defense lawyers here. In fact, we will be...
I'm referring to my client. Don't embarrass me.
Yes, you call them out. You know, Hello, you are the learned one. So, ladies and gentlemen, please, thank you so much. I think we are well out of our time. A little bit, 5 minutes is not too bad. Let us take it on tomorrow and have a good evening. Zuki, so we can stop here now. Thank you, madam.
Thank you, Elsie.
Thank you. Thank you, guys.
Thank you.
Thank you.
Thank you.
Thank you.
Very informative session.
Brilliant. Thanks.
Thank
Bye-bye.
you.
Bye, guys.